because all of them have been working as part of the African group, and their voice has been very influential in the negotiations. Also, thanks to the advice that we have been providing to them. And so I framed my presentation into about 3 key research questions, which I would like to elaborate on. One of them is, should African states apply for contracts or sponsor contractors for seabed mining in the area? And I'm assuming that the presentation given by Professor Nabulele has laid the groundwork, the foundation, for me to not go back into some of those basic ideas around seabed mining exploration at the area. So I'm assuming that he has laid adequate foundation for me to build on it without going back to some of those basic ideas. So the second key question is, what are the pros and cons of African states applying for contracts or sponsoring contractors at the ISA? And what are the key issues that African states should consider when developing their own national legislation to participate in seabed mineral activities in the area? First of all, let me give a brief overview of Africa and seabed mining, because it's an aspect that has not been much talked about. Seabed mining, prospecting and exploration has been going on in Africa for quite some time. Within national jurisdiction, 2 countries stand out in this area, and they are Namibia and South Africa. In Namibia, marine diamonds exploration has been going on since the early 1990s, whereas in South Africa, exploration for manganese and phosphates has been going on since the 2000s. But for this presentation, my primary focus is not national jurisdiction, but seabed mining in areas beyond national jurisdiction, which Professor Nabulele explained very clearly. I think in around 1988, yes, around 1988, African states have for a long time recognized the economic importance of seabed mining for the continent as far back as 1988 in the Kampala Program of Action on the Development and Utilization of Mineral Resources in Africa. The program saw seabed mining as a possible future alternative source of nickel, copper, manganese, cobalt, and other minerals that are produced in land-based mining operations. However, for about 3 decades after the Kampala Program of Action, there was no further supranational level discussion of seabed mining in Africa, despite the adoption of the 2050 Africa's Integrated Maritime Strategy in 2014. The maritime strategy provides a broad policy and institutional framework for the sustainable exploitation of Africa's seas and oceans. Yet, it largely ignored the importance of seabed mining as a blue economy sector. However, the African Union Agenda 2063, which was launched in the same year as the maritime strategy was launched, recognized seabed mining as a potential blue economy activity. And the goal was set to commission and complete seabed mining prospecting in Africa by 2023. That year has since passed, and practically nothing has been done, let alone completing seabed mining prospecting in the continent. In 2017, a workshop was organized in Kampala by the African Mineral Development Center and a number of its partners, which included the UNECA, UN Economic Commission for Africa, to raise the interest of African states in the development of mineral resources in Africa's continental shelf and the adjacent international seabed area. In this workshop, they talked about capacity building of African states to engage in seabed mining in the area. In 2018, UNECA argued that it was in the strategic interest of Africa to join other states in participating in seabed mining in the area. And the 2019 African Blue Economy Strategy boldly recognizes the importance of seabed mining to Africa's economic transformation. ABS, which is the Blue Economic Strategy, anticipated that seabed mining in Africa's EEZ could contribute up to 76 billion US dollars by 2030 and 123 billion US dollars by 2063 to Africa's economy. Despite extensively discussing seabed mining, however, ABS is completely silent about Africa's participation in seabed mining in the area. So its main focus was on seabed mining within Africa's national jurisdiction. So that provides a context of seabed mining in Africa, especially with regard to Africa's involvement in activities in the area. But of course, with the negotiations that have been going on for so many years now, exploration regulations were passed around 2013, and since then, exploitation regulations are still being negotiated. And we hope that by summer this year, they will be able to come to an agreement and adopt some documents. Though some have said that it's not looking quite likely to happen, but we'll see what happens. So I will speak a little bit about participation in seabed mining in the area, although Professor Nabulele laid some context, but I think I need some details in order to ground further discussion. So the area, as he explained, is that part of the ocean that is beyond the limits of national jurisdiction. It has the status of the common heritage of mankind, so it belongs to all of us. It's also subject to the UNCLOS legal regime, so it's regulated by the UN Convention on the Law of the Sea, and also the institution that actually carries out the implementation of UNCLOS is the International Seabed Authority, which is headquartered in Jamaica. Participation in activities in the area is through contracts that are issued by the International Seabed Authority. These contracts can be issued directly to a state party to UNCLOS, or contracts, it can also be issued to enterprises, natural or juridical persons that are sponsored by state parties to UNCLOS. In the ISA, they have what they call the enterprise, which is more like a business entity that is owned by the ISA. Is going to get involved in seabed mining activities, pretty much like a private entity. So the enterprise can also be awarded a contract. It is an organ is akin to an organ of the ISA. So it's like an ISA-owned contractor or an ISA-owned company, just like you could have a state-owned company. However, the operationalization of the enterprise has not yet been completed. So it's still ongoing. There's been calls to fully operationalize it, but that has not yet happened. I think someone has been appointed, Eden Charles, to lead affairs in that aspect, but it has not, it does not hold any contract at the moment. Now, non-state parties are not eligible to sponsor contractors. Fortunately, there are not many non-state parties. I think foremost among them is the United States. So they are not eligible to sponsor a contractor to apply for contracts to the ISA. Typically, exploration contracts are for 15 years. They are granted for 15 years, but they can also be extended for periods not exceeding 5 years at a time. There is no actual exploitation going on right now because the exploitation regulations have not been fully negotiated and adopted. So all activities in the area are exploration, not exploitation. Now, who can be sponsored for a contract? The first is state entities themselves. So a state can put itself forward in its name to obtain a contract from the ISA. Natural persons or juridical persons that possess the nationality of state parties or that are effectively controlled by them or their nationals. This point is very loaded. And I don't think there's time to go into details of exactly what effective control means. It's a concept that continues to evolve. There's no consensus on exactly what it means for a state to have effective control of an entity that it is sponsoring. It's unclear whether it is limited to having legal control, whether it includes having other forms of control like financial control and others, and regulatory control. There are a number of recommended measures that a state should take in order to gain effective control over an entity. One of them is to enact a sponsorship law, so enact legislation that governs sponsorship of contractors. So the sponsorship law will hold contractors to compliance with the UNCLOS regime, which includes the rules and procedures of the ISA. The sponsorship law will also set domestic sanctions for non-compliance with that UNCLOS regime. Another measure that a state can take is to provide greater detail, really more stringent standards in its own national law for a contractor's liability obligations than are currently provided under UNCLOS. The reason for this is that the state may be liable for its negligence in controlling, in regulating its sponsored entity. So one measure a state may take would be to enact more stringent regulations than are currently in UNCLOS. Another measure a state may take would be to ensure that there are clear and accessible legal and judicial processes within its own jurisdiction for any claimant against a contractor, indicating causes of action and remedies that are available within its own domestic domain. A state can also consider using indemnities in the event of state liability to protect itself from liability, because a state can be roped in by the acts of the contractor if the state is shown to have neglected its due diligence obligation towards the contractor. A state may also consider requiring insurance and or some form of financial security from a contractor on terms that would enable the use of those mechanisms to cover costs that may arise against a state. Now, the next core issue has to do with the responsibility of sponsoring states, because it's not enough to sponsor. When you sponsor, you incur liability or responsibility. Under UNCLOS Article 139, a state has a responsibility to ensure that the sponsored contractor conducts the Seabed minimum activities in a manner that complies or conforms with UNCLOS provisions, or if the state neglects to do that, it may face liability for any harm that is caused by the actions of the contractor. The Seabed Disputes Chamber of the International Tribunal for the Law of the Sea issued an advisory opinion in 2011 to elaborate a little bit on what this responsibility means. And the tribunal indicated that it is a responsibility, it's not a responsibility to achieve the results that the sponsored contractor complies with UNCLOS. Rather, it is more like a responsibility of due diligence. So as long as the state shows that it was diligent in regulating the contractor, ensuring that it complied with UNCLOS and other applicable rules and regulations, that satisfies this responsibility requirement. Even if harm eventually occurs, the state